very much, Joe. For those who didn't know, I was fortunate to learn my business skills from Joe as working under him for a couple of years, and so I'm fortunate to have brought that level-headedness with me today. And I'd also like to acknowledge the other large, Joe and Dr. Campbell Rankin are two large imports in my career, and a lot of what we're talking about today I will attribute to Dr. Rankin. We will be seeing his views and perhaps debating them. I know that some people disagree with them, and I know that one of whom, Dr. Ailira, is not here, and last time I spoke on this, we had some nice to and fro in the audience. He's in chambers at the moment, so I'll be spared that. However, if anyone else would like to interject, heckle, maybe not heckle, or ask questions, please feel free. I'm happy to go off on any tangents. Cool. So, we're going to start with some really basic material. And the reason why we were built to, and the importance of absolute core trust law is tested and will flow through all of the tax implications that we'll talk about and all of the things that we can build with it. Now, my father's a toolmaker, and I spent part of my youth in a tool room, and so when we talk about we can use trusts like iron, and we can twist them and warp them like iron, and essentially build anything out of there. I'm quite firmly of that belief. So, it's down there. It's facing away. There we go. So, first of all, I'm going to talk about absolute entitlement. So, the simplest of trusts we could have is where a trustee, T1, holds some trust property, we have black acre and white acre, for the benefit of a beneficiary. If they hold it absolutely, the beneficiary can call for the trust to vest at any time, as we know as we recall from Saunders and Vautier. Beneficiary can appoint and direct the trustee. They are absolutely entitled to the income from the trust for tax law purposes. But even in this simplest and most basic of trusts, it might not be the case that the beneficiary is absolutely entitled to the assets at all times. And this depends on the trustee's right of indemnity. So if the trustee is purely in a passive aspect here, that they hold black acre and white acre, there's no debts, doesn't trade, the indemnity would be limited such that there would be an absolute entitlement to the assets. But if there is not, if there is a mortgage, or this is some kind of trading trust, and there is the likelihood or possibility of assets or debts arising, then the trustee will have a right of indemnity, and the beneficiary cannot be absolutely entitled to the asset until that right of indemnity is satisfied. Now, the ATO, in a tax ruling that it's had in draft form since 2004, has struggled with the concept of absolute entitlement. That's its views. It's now 14 years in draft and still unsettled. And that the ATO would hold that there is potentially an E5 event, that is a CGT event from a beneficiary becoming absolutely entitled. So if we had a trustee has a right of indemnity and then that goes away, suddenly there's CGT, notwithstanding that they've been entitled to it the whole time. Probably they would ignore that in the case of a simple trust. But this principle is very important as soon as we get into something slightly more complex. So, basic trust number 2. Now we have a slightly less simple trust, and there are two beneficiaries who have an absolute entitlement to all of the income from Blackacre and Whiteacre. Now, one of the beneficiaries cannot alone call for the vesting of the trust, and whether they can, besides the right of indemnity, holding them, calling upon the trustee to marshal the assets to meet their rights as beneficiaries, their entitlement will depend upon the nature of the assets themselves, whether the assets are fungible. So if there was two beneficiaries and but one property, and they say, I want the trustee to distribute this to me, well, how could that happen? Now maybe the trustee has to issue to them jointly. If there was 1,000 BHP shares, it would be quite simple. They would be held equally for them. It also depends on the intention of the trust. Is the trust set up such that the beneficiaries are intended to be able to call for the particular assets, or is it drafted into the nature of the trust that is intended to continue? Now, when we draw our trusts or print off our standard trust deeds or write that in a will that we shall hold something on trust for someone, kind of skip over these and then set up a trust that we often will have a lot of complex circumstances, and these will depend on these very minutiae. Now, the power of appointment in this trust, of course, would lie with beneficiary 1 and 2. Of course, we could separate out that power of appointment, but by default it would be with them. Still in basic trusts. So now we have a basic trust, and we have Blackacre. The beneficiary 1 is absolutely entitled to the income from Blackacre, and beneficiary 2 from Whiteacre. Now, we're only slightly more advanced than the previous step, but how many trusts are there? So if we're, so this is not uncommon to arise in an estate. There will be one trust estate. It's a type of trust when the administration starts. As the administration starts, it's like uncovering dinosaur bones. There has been trusts, a trust left for child 1 and child 2. And those trusts were always there, and as you administer the estate, you uncover them. Have you created 2 trusts? You start off with 1, and now there's 2 or multiples. Now, the case of Livingston would hold that you don't. Room and Edwards, the 1989 case, considers the difference between there being a settlement and trust estate, and it holds that you can have multiple trusts, that you can create different estates, trust estates, without necessarily settling them, having a different settlement. Now, obviously, I could set out and say I hold Blackacre on trust for beneficiary 1 and Whiteacre on trust for beneficiary 2, and declare 2 different settlements, of course. Or I could start off with 1 trust equally for both of them and then declare it separately. And each of these will trigger CGT, potentially stamp duty if it's on real property in South Australia. But if we have it built into the mechanism of the trust and it happens somehow, then there is no CGT. There is no creation of a new trust, even though we end up with multiples. And these concepts lead us to go, what can we do with trusts? We can build them to automatically do this. Now, what happens with the right of indemnity? The right of indemnity against a trustee may or may not be separate depending on how you draw it. So you want to be careful to make sure that beneficiary 1 cannot cause some kind of loss that affects beneficiary 2. Now, still in very simple things. New trustee, version 1. So what we're going to do is we started off with trustee 1, and now we're going to do the most basic thing we could do, and that is add a second trustee. Now let's run through the principles. Is this still the same trust? Yes, it's continuing on, it hasn't stopped. Are the rights the beneficiary has against the trustee the same? Yes, it must be. There is an express exemption in 71(5)(d). Now, in capital gains tax, and it says that change of a trustee of a trust does not constitute a change in the entity that is a trustee of a trust. So when we see accountants talking about trusts as entities, this is why it's because tax law treats it, deems it as an entity. Of course, we know as lawyers that it's not, and that it is a trust is a relationship. So. We haven't changed this trust law entity. The entity has continued on, and so therefore there must be no CGT. I also note that there would be joint liability and indemnity. Now, here we haven't removed any trustees, we've just added one. Now, we're going to remove one. Again, a simple transaction where we remove the old trustee and appoint a new one. You might do this under a power of appointment that the appointer has. The old trustee might retire, or you might do it in two steps: add one and then retire. And so now we're going to come to a core debate, which is termed the new trust view versus the no new trust view. So this is the no new trust view, and this is the simplest as I can put it. We have one trust with two yolks, one egg, and it is not split. So, the no new trust view. So upon the change of trustee, it holds that it looks first to see whether or not any resettlement has occurred, and if in the opinion it has, then states a conclusion that a new trust has arisen. So we might look at the substratum of the trust, we might look at the relationships, the continuum of the trust. Some of the, now I must admit, this is the majority view of commentators. This is not my view, but this is the majority view. Now I'm going to try and challenge it. The no new trust view holds that on a change of trustee, there is no new trust. Do you need to have a settlement to create a trust? Well, obviously, there's no settlement on a testamentary trust. The typical argument in favour of the new trust view is Reuben Edwards, and where it talked about there being multiple trust estates which triggered CGT, but that was about separate estates and has a different question to what we have in Australian capital gains tax, which is there a settlement? Which is very broad, but it should not be confused with the UK CGT, which considers whether there is two or more trust estates. So in Reuben Edwards, they said, but when is a settlement a separate settlement? There are a number of obvious indicia which may help to show whether a settlement or a settlement separate from another exists. One might expect to find separate and defined property, separate trusts and separate trustees. One might also expect to find a separate disposition, bringing the separate settlement into existence. These indicia may be helpful, but they are not decisive. For example, a single disposition, e.g. a will with a single set of trustees, may create what are clearly separate settlements, relating to different properties in favour of different beneficiaries, and conversely, separate trusts may arise in what is clearly a single settlement, when the settled property is divided into shares. So the test of is there a settlement or not is not what defines whether there is a new trust.
Adrian, can I interrupt you?
Please do.
And ask you a question?
Yes.
For this purpose, what is a settlement? It's an interesting notion to me that a will giving a piece of property to a trustee is a settlement. But yes. I'm inferring from this quote that, at least in Reuben Edwards, it's thought to be a settlement.
Well, no. In particular, what we're looking at is, so a will could be a settlement, but out of a will you might devise a number of trusts. And so and so if the will is the settlement, there is but one settlement. because you can only die once, unfortunately. But you might set up in your will trusts for 10 or so beneficiaries. And so, and at the time of your death, there will be but one trust estate. And as it becomes administered, those 10 different estates will come out. But none of them have been separately settled.
Does a settlement therefore mean, for this purpose, a transfer of property to a trustee?
A settlement is I would say it's a circular definition. It's what so there are certain things that are clearly a settlement, and then there is an expanded set of terms which encompass what is a settlement. So I could settle a trust. I could say I'm going to put $10 on trust. I could have a settlement that comes out of my will. I could resettle a property. And again, this, but what actually constitutes a settlement or a resettlement is, it goes around in a circle.
Sorry,
yes.
Perhaps your point is that as it passes from administration, as you pass from administration to setting up the testamentary trust, that is a separate settlement. Is that your point?
Well, really my point is a much more basic one, Joe. What is a settlement? And if I think in terms of the creation of an inter vivos trust, then somebody, a settlor, will normally pay an amount of money to somebody to be the trustee, and there is the settlement. Now, when I then see on the screen the notion of a settlement created by a will, I start to wonder whether I'm right when I think in terms of what a settlement is, which I think is probably the transfer of some property to a trustee to hold on trust. And if that's so, well then, yes, it can work by way of a will. If I'm wrong in my definition of settlement, well then, I've lost Adrian's
my evasiveness in answering this is because I don't agree with the no new trust view. I follow Campbell's view of the new trust view, and in which I think has a much clearer definition of what constitutes a settlement and a resettlement. And I think we're on the next slide. Yes. Yes. And so I will set out what my view is, and the reason, and while I'm trying to set out the no new trust view's definition of a settlement, in my view it's circular, and I think it's problematic. Others might be able to set it out. I'm trying to set it out as a steel man argument, in that I've set it out as best as I can. But I admit in my heart that I'm not convinced by it. So the no new trust view, the problems with that, so you can have trusts without a settlement or a resettlement. And so if you're trying to say a settlement is the thing that creates a trust, well, we can clearly see that we can create trusts without a settlement. So it can't be the thing that creates a trust. In the full court case of Clark against the Commissioner, where it sets out what constitutes a resettlement in the case of a unit trust and talked about a continuum, it says that if you change the continuum of the trust, its constitution, its property and its membership, then you will resettle the trust. And but in Clark, they were not saying that this is the only way in which you can resettle a trust, because you could quite simply say, I resettle a trust for this on this exact same constitution, property and membership. So the no new trust view cannot rely entirely on Clark because it's not conclusive. And the Charter of Rights and Obligations cases, such as Reball Settlement, Mazarine was the one that I was picked on last time with, and that falls into this set of cases. There's a bunch of early cases from 1800s and early 1900s that look even at a simple relationship and say a change in the Charter of Rights and Obligations constitutes a change in the trust relationship. that constitutes a resettlement or a new settlement, they don't consider the trust relationship being the relationship between the trustee and beneficiary. Again, I admit this is the majority commentator view. So now I talk of the new trust view. Now, this is my own invention, this analogy of a starfish. Now, I'm not sure if you know that if you take a starfish and you cut it in twain like this, you will end up with two starfish, both of which are the original. The starfish will regrow its remaining limbs. When it starts off, it had 6, and now there's 2 starfish with 3. In 6 months' time, you'll have 2 starfish which have 6 limbs. So that is in essence how the new trust view works. So the new trust view looks at the in personam rights of the trustee. Now I can see someone taking photos. If you, I will send out these slides, and I have a paper that I've just formatting, and we'll send out as well. So that will be emailed out to you by the forum organisers. So the new trust view, we look at, and the test is the in personam rights. So as we know, a trust is a relationship between the trustee and a beneficiary. And the trustee is impressed with the trust obligations upon them. If you change the trustee, then you change the trust. You have resettlement. And that is what I would suggest constitutes a settlement or resettlement. A change in either of those. So of course you can do it by changing the continuum, but if you change that fundamental relationship between the trustee and the beneficiary, it's an in personam rights, it's changed. Just as if you have a relationship between a lawyer and a client, you change the lawyer, you've got a brand new relationship, don't you? I suggest that this is envisaged by sections 14A2 and 14A of the Trustee Act, envisage that you can have multiple, you can create multiple trusts, or you can appoint different trustees to one trust, and it will create new trusts out of one, and that every time you change trustee or appoint a new trustee, it will resettlement. It will cause a resettlement. So that is the simple answer. A change in trustees is a resettlement under the new trust view, and that is my simple answer. And something that doesn't seem to be picked up by commentators generally, but is known to us in South Australia, is that we have a South Australian case on this, Dido, where it was expressly said they reject the notion of the appellate, where there was a trust split in this, and we'll come to trust splitting shortly. Reject the contention that the alternative acquisition of a complex tax scheme resulted in splitting of a trust into 2 identical copies. On the contrary, the split trust is a new one carved from the progenitor trust. It has a different trustee, it has different property, the nature of the trust obligation has changed. The beneficial interest of the unit holders has changed. No clearer could there be a statement in support of the new trust view. So, what does that mean? So, generally, it's been fine with that the new trust view can exist because there are specific exemptions in, say, 71(5)(d) of the Stamp Duties Act that says a change in trustee doesn't trigger stamp duty. So it doesn't matter whether it's a change, whether it resettles it or causes a change in trust. It's fine. So then it matters for settlement or declaration. So now we come back to what constitutes a settlement. In the ATO's view, historically, they have said E1 needs a settlement or declaration, so it doesn't matter. It'll be fine on a change of trustee. E2, you're transferring from one trust to an existing trust, that's fine. In CGT event A1, which is transfer from one person to another, there's no express exemption. And then so then you end up into a circular argument of that you don't trigger A1 if it's a new trust, and it's not a new trust if you don't trigger A1. So it's circular. The no new trust view, you would look to I would suggest what you test is you look to the beneficiary's interest, and so and buckled as a High Court authority for this. Now, where we have some great fun is that halfway through last year, the ATO put out TD 2018-D3, and they've ostensibly tried to attack trust splitting, which is the starfishing, creating two trusts out of one, because they generally don't like things that are fun. Not things. But what I found interesting is that, in my view, in my reading of this, they have adopted the new trust view. And if the ATO have adopted the new trust view, they have turned every single change of trustees into a resettlement and a CGT event. So now, I got to say, I don't think they're going to apply that, and because that would be calamitous. What I think will happen instead, they've sat on TD 2018-D3 for some time. They've had a lot of angry feedback from the majority of commentators who follow the no new trust view, because they seem to have adopted the new trust view. I've pointed out to them that I say, this is great. I'm glad that you agree with me. You're going to hit a whole bunch of things you didn't intend. And so they've got a lot of thinking to do. I don't think they're going to apply it, but they have to do a lot of wiggling and revise their argument. So they may, in fact, do a backflip, or they may just come up with something nonsensical. And where this leaves us with a problem is if the ATO has hadn't actually adopted a clear view one way or the other, it would be easier for us to do things. So now we're going to talk about some things we can do. I don't think that the new trust view, that we create a new trust if we do this. If first we appoint trustee 2, that is step 1. At that time, there is the same trust. And then we remove trustee 1. Then there is the trust is obviously continued. I think for CGT purposes, you would not trigger a change in trustee. You would not trigger a settlement, even if the ATO has adopted the new trust view. If you were doing this expressly to get around that, you'd have to consider Part 4A, the anti-avoidance provision, which would be problematic. I just want to note that if you are doing any kind of change of trustees for the purpose of, and you wish to make sure you get a stamp duty exemption, there are 3 parts to it. So you need to transfer for retirement or appointment of a new trustee. There must be no benefit to a trustee or another person. This is not something that will be typically enforced unless you're doing something complex or fun, and then the revenue tends to be quite technical. Be careful if you have a clause in your deed that says a beneficiary who becomes a trustee can't be a beneficiary, because if say you set up a new company, typically it'll be a beneficiary, and as soon as you appoint it as trustee, it's removed as a beneficiary, in which case there will be a detriment to a beneficiary, and this was considered in DIDA, and one of the reasons why the scheme failed. And as an interesting note in DIDA, in my reading of it, it was held that a change in a trustee, appointer, and guardian constituted resettlement. I don't think that's going to be followed. I just want to point that out there because that's, to my mind, something quite vanilla. So, of course, you could always resettle a trust. You could expressly say, I have resettled it. You could do it accidentally. You could do it to establish a cost base. You could resettle part of a trust on a new trust. This would cause CGT extension. Now I'm going to talk about we're going to pick apart trusts and the notion of a subtrust. There are about 4 or 5 different things that have been called subtrusts. I have taken it upon me to name them. The first of which is there is a chain of trusts. So T1 holds Blackacre for T2, who holds that beneficial interest on Trust 2 for B2. So ultimately, everything is for the benefit of beneficiary 2. The ATO would say that you would look through and beneficiary 2 would have absolute entitlement to Trust 1. But if you have an active trustee, so if the powers of Trustee 2 are in some way that they have the ability to do things and make decisions, beneficiary 2 could not call for a winding up of Trust 1. Only Trustee 2 could. Now, if you were to wind these up and so merge Trust 1 into Trust 2, then you would, it's going to be an absolutely entitled transfer, so there's no going to be CGT. And these two estates, different trust estates, would merge. So, now, one example of where this arises, just say I'm doing a change of trustee of the discretion of the trust, and the trust owns intellectual property and also land. And I say that all of the on the change of trustee, all of the property is owned by, it will be transferred immediately to the new trustee, being say Trustee 2. So the intellectual property transfers immediately. The land transfers only when it's registered. So for some time, you have this scenario. We have the land is held by Trustee 1, who must transfer it to Trustee 2, who is holding it for the benefit of the trust. And so in this example, the IP would be Whitehaven. Now, I had a client the other day who was trying to do some succession planning, and they wanted to break up a trust and come through the problem of having one trust controlled by 2 different people, and they originally wanted a trust split. But I said, well, I'm sorry, you can't do that anymore. And they said, well, what happens? And I said, well, you could do this. You could do a vanilla change of trustee and just leave one of the siblings in control of the first trust, and the other, the first trustee, and the other sibling in control of the second trustee. Now then you would have to change some powers of appointorship and guardianship so they can control it. But in that way you can split this up and effect a quasi-trust split, but without triggering CGT. Now I also suggested that given that this is a contentious issue, you would want to put it before a private ruling. Another type of subtrust that is called subtrust in various commentaries.
Sorry,
yes.
You had sorters and board here up there in the previous slide.
Yes.
What's the relevance of?
Yes, so beneficiary 2 cannot call for the winding up of Trust 1 if Trustee 2 is active. So if the trustee, even though this is a simple bare trust, if they have some kind of active duties to consider, then that they cannot call for a winding up of it, even though you would say that they're absolutely entitled. Now, if this is just a simple custodian trustee who has no duties other than to hold it, then of course beneficiary 2 could wind up Trust 1 or Trust 2 or both. Now I know that a simple bare trustee could have significant powers. If we look at the fund litigation around Gina Reihart's trust, she vested her trust, a discretionary trust, for I think it's 4 children who held this equally. She remained, though, in control of the trustee. The trustee gets to exercise the voting power of the shares, which determines whether a dividend comes or not. So even though we had what we ended up with was a very simple bare trust, and there was no CGT upon that vesting. Even though we had just a simple bare trust, the trustee reigns supreme. And this is the classic debate of who is in control of the trust, the appointor or the trustee. The appointor is clearly not. The appointor is only the controller of a trust for 2 reasons. One, that the professionals who set up the trust will often say so. and the accountant says the appointer is the controller, and the client says yes, of course, sure, and everyone acknowledges that. And then when they die, it turns out that the trustee has a lot of power. The appointor can appoint or remove the trustee, but perhaps the trustee has the power to amend the trustee and remove the power of appointment. Perhaps they can frustrate it in some way, and if they're going to litigate, the trustee will draw upon the funds of the trust to litigate against the appointor, and maybe they're successful or not, but they're certainly more powerful for that time. You should not assume that the appointor is the control of the trust. The other reason is because the tax officers said that the trustee is, the appointor is often a controller of the trust, which is probably not the best reason. So, umbrella trust. Here we have we have separated out two trusts, so two sub-trusts. So we have one class and another class. And in this example, they have identical sets of beneficiaries. Say it's an ordinary discretionary trust for three potential beneficiaries. The same list on each side. Now, often under a power of appointment, we can say we will hold some set for a different set of trust, on a sub-trust separately for some set of beneficiaries. So we could say in an estate planning context, so you can see where I'm talking about estate planning now, which is what it's supposed to be about, is that we could say I want Blackacre to go to one set of beneficiaries and Whiteacre to go to another. So now we haven't created a new trust. It's still the same trustee. How do we control Blackacre and Whiteacre? We can use our power of appointment. We can appoint. We can say that beneficiary one has the power of appointment over Blackacre, and so if they wish to, they could appoint a new trustee, potentially resettling it under a trust split, and they have the power of guardianship, the power of veto over what happens to Blackacre. If there's no change in trustees, no change of beneficiaries, we will not have any problems with stamp duty. I note though, it's important how you do this. In the case of Lam and Kim, almost exactly this thing happened, but they declared it, and they said, we declare and we hold this separately on trust for a subset of the beneficiaries. Now, we come back to our question of what constitutes a resettlement. An appointment, an exercise of a power of appointment can be a declaration. And it is a special power of appointment that can do this. So this can be done, but you need to be careful. It's the simple answer. Now, I note that in this example, there will be a right of indemnity from the trustee across all the sub-trusts. So that's going to be a problem for your estate planning. Another one is what I'm going to call an absolute sub-trust. And so again, you exercise your power of appointment and you say that I'm going to hold this particular property on a separate fund for some beneficiaries. This happened in the case of Oswald, and he said he declared that they held some shares in Borough Fertiliser absolutely for beneficiary one. Interesting, because the trustee has a right of indemnity against the trust assets, there was no absolute entitlement and then therefore no CGT in E5, but it already created a separate trust, so there's E1. But I think that you can work your way between E1 and E5 and set up something like this, because there is if you're not declaring absolutely, you're not going to trigger E1. And if you're not, and if the trustee's right of indemnity still applies, then you're not going to trigger E5. So you could do this. Without CGT. I know that if you're giving an asset to a particular family member, there is stamp duty exemptions. One more, and this is what I'm going to call an income subtrust. This is one that I don't like. A lot of this, this is where. So, in a lot of trust deeds, after IT, a tax ruling was set out, the Commissioner said that he wants a particular clause in trust deeds, and people began putting this clause in there that said until income until paid to a beneficiary shall be held as a separate fund. Now I often poll the audience, has anyone ever seen an accountant declare income, not pay it immediately, and then say, now I'm going to account for it as a separate fund? I actually had one accountant once put their hand up. I nearly fell off the stage. But I don't know, has anyone ever seen an accountant keep track of that? I haven't. I have seen accountants keep track of unpaid present entitlement sub-trusts, which are effectively the same thing. So they declare an unpaid present entitlement and hold it separately. I think they're terrible. If you've got this in your trust deed, I've got some QC papers who suggest that it should be removed. I'm happy to forward you the papers so you don't think you're just relying on me. This has no benefit, and it's never done in practice, and so you're just enabling people to breach their trust deeds. Of course, if you're a litigator and you're looking for something that the trustee has done wrong, have a look at this in the trust deed, because it's fairly common, and almost no trustee follows it. So, also, how can you declare a trust over income? It's not a thing, it's a tax law concept. So, on home stretch. So now I'm going to talk about another estate planning thing. So we're trying to, from an estate planning perspective, what I see the difficulty with the discretionary trust is that it's not like a share or a unit or owning something individually. You've got this one amorphous blob, and you typically have one blob owned by one founder, and they'll have multiple children, and how do you pass that blob on? So so here is another way. If we set up a trust, a class trust, we can set this up and say that we can give pieces of control in the powers of the trust to particular people. So I could say, I give to someone the right for, I'm going to call this a distributor power, to direct the trustee to make appointments of income or capital. So that's a very strong clause. Obviously you're not going to want it for like, it's not the best for an asset protection point of view, but it does give you control. And what that does mean is that you can have multiple people who hate each other in the same trust controlling their one piece. So if you give someone a distributor power, and then perhaps a guardian power, a power of veto over decisions of the trustee, and then perhaps a power of appointment, so they can appoint and remove the trustee, but only into either a particular asset or a share. So here, 50% of the trust fund. So you've got two children, each of them have control over 50% of the trust fund. Then you can create the same practical effect as one unit trust owned by multiple discretionary trusts, but all in the same trust deed. It may be possible to take your existing single amorphous blob discretionary trust and convert it into something like this. Now, you're going to want to have your beneficiaries have some kind of relationship with each other. If they totally hate each other, well, I'm sorry, that's bad. This is probably not the structure for them. But if they can work together, let's say I want to control the BHP shares and I want to control the Rio Tinto shares, you can do this. Or I want to control Blackacre and its income and its investment decisions, and you control Whiteacre, and we have one trustee that we're both directors of, and that we see the same accountant and get a trust return done at the end of each year. And I know that you're not going to try and play any games, but if you do play games, I have control of the trustee over my piece, and if worst comes to the worst, I can always appoint a new trustee, accept potential tax consequences, take my bat and ball, and go home. You could also define this. So you should. This is an ideal thing for setting up in a will. So you have this for multiple generations. So generation 2 and 3, you define the class according to. The most common things I've seen: 1, shares in the trustee. So you just simply change the shares in the trustee and each have a percentage based on that ownership interest. Or 2, per capita or per stirpes, descendants. So that means if you have 3 children, they each get a third. And if they have 2 children, then they each get a tenth, and so on and so forth, and so it automatically devolves. You can also create hybrid unit trusts that have asset protection that is locked to someone's bloodline. You can lock this to a particular bloodline as well. There is some family law cases that have discussed this. One that's been successful on a particular bloodline trust, others that have been unsuccessful. So when you're creating a class trust, you're not going to have separate assets. You could also, the other example to use this is that there is for the widow's home. You say, I'm going to give the widow, I'm going to give you control over a power of guardianship over your home. You can veto it. Instead of creating a life interest and all the pain in the ass capital gains tax consequences with that, just give them a right under the trust deed to control it. It's a superior right, in my view, to a life interest, and you don't have any tax consequences, and you can do it in in a couple of pieces of paper. It's quite simple. Now, recent case law, Aussie golfer. So Aussie golfer came out at the end of last year. It considered a superannuation act and the sole purpose test. Essentially, what happens? So if you have an asset in your super fund, for example, a house, you can lease it out to someone unrelated, but you can't. But the Commissioner has taken the view that if you lease it out to, say, your child, even at market rent, you're using a superannuation fund for some other purpose, so here to benefit your child. The first thing is the court considered was that no, if you're leasing this out on an arm's length basis like that, you're meeting the sole purpose test. It's not going to cause problems to your super fund. That's fine. So that's great news, and that's probably why it's on appeal. It was a full federal court case at the end of October last year, and so hopefully we get some special leave in the High Court. Where it's interesting for today's purposes is that they can, so the trust was set up by a company that has Adelaide, it's called Domicom, and what they have is one huge trust that says it's going to manage hundreds of properties, and what they say is that for each property, if Joe joins Domicom and he puts, he finds a property, they're going to hold it in this trust, but on a separate, what they call a sub-trust for Joe's super fund. And so essentially he controls it. Now, for all intents and purposes, each of these sub-trusts was totally separate to the others. There was no similar rights of indemnity, the beneficiaries were the same, the assets were chosen by the beneficiaries, they had total control of it. Notwithstanding that they called this all one trust, I agree with the court that, respectfully, that there was it was a separate trust, and in which case this reinforces what I was talking about earlier, that you can set up one trust that automatically sets out separate sub-trusts. There's been some discussion as to whether this goes against the new trust view. I don't think so. I think it's in support of it. But yes, so you can have a sub-trust be a separate trust. So now, homestretch, trust splitting. We talked about our starfish before. We can create a new trust. Trust split is where trustee 1 retires from Whiteacre and trustee 2 retires from Blackacre. And so you end up with, in my view, a starfish split. You'll have separate TFN, ABN, GST registrations, and now under the Commissioner's view, this creates 2 trusts. Watch this space. It might he might change his mind. He might not. Thank you. So, notwithstanding this, trust split can still be useful. You might, for certain purposes, Revenue SA accepts it as not triggering stamp duty. If you're doing it for land tax purposes and you change beneficiaries, they generally don't. If you're, I've got a number through and they've been happy with them. I've also had a number where they haven't been happy with them. So There's so you might do that. You might split the trust and then apply some capital gains tax rollovers to deal with. So CGT will be your typical problem here. And then you end up. I have seen a return to trust cloning, mainly because so trust cloning was you would create a separate trust that has the same terms as the original. And up until 2005, or maybe 2007, there was a view that you could then transfer assets from one to the other without triggering CGT. That law was expressly amended so that you can't, but it didn't catch trustworthy. But notwithstanding that you're going to get hit with CGT on transfers to what is clearly a new trust, for the purposes of estate planning with intertwined trusts, you might do this. You might wear the CGT because there are capital losses to offset. You might use the small business capital gains tax concessions. There is now a small business rollover, and also there's a same asset trust rollover. So if it's the same trust or a similar trust and you're rolling an asset from one to another, you can avoid CGT. Of course, there might not all be CGT on all the assets if there's trading stock that you're transferring in the ordinary course of business. There has been a flurry of transfers of commercial property now that we no longer have stamp duty on it, moving it around into new entities so they are not aggregated for the purposes of land tax. Let's see how many years until things change yet again. Now, obviously, unfortunately in South Australia, but not other states, moving businesses around and non-landholder units and shares don't attract stamp duty either. With that, I'm finished and on time.
Thank you, Adrian. We do have a couple of minutes, so if anyone's got a question, please. No?
I've been let off. Appreciate it.
Well, as usual, Adrian has illustrated the tremendous usefulness of trusts and their flexibility, while also going through some tax aspects and other technical matters. We conclude this session with a better understanding of the possibilities of the Craftwork trusts in an estate planning context. Thank you very much, Adrian. I'd just like to remind you to fill out your evaluation forms.